The U.S. Supreme Court has only approved two types of checkpoints. And those types of checkpoints, one type is the sobriety checkpoint. The sobriety checkpoint, the rationale that the U.S. Supreme Court used to rule that they are lawful is that because a drunk driver poses an imminent danger to other motorists on the road at that particular time, that it serves a compelling government interest to protect other individuals by identifying those impaired drivers and removing them from the road so that they don't pose an immediate danger. So the rationale being that the law enforcement purpose of finding a drunk driver is superseded by the fact that that drunk driver poses an immediate risk and therefore should be removed so that they are no longer a risk. That is the rationale that the U.S. Supreme Court uses to justify a sobriety checkpoint. The other type of checkpoint that the U.S. Supreme Court has upheld was based upon a case from 1976 called U.S. versus Martinez-Fuerte. And that was based upon a permanent checkpoint installation in Southern California where an individual was challenging his stop and ultimate arrest at this checkpoint where he was stopped and his immigration status was questioned. And during the questioning, the agents directed this individual to a secondary inspection where in the course of the inspection they found it was either illegal narcotics or illegal aliens in that vehicle. And the U.S. Supreme Court upheld brief suspicionless immigration stops at permanent checkpoint installations set up near nexus points for border traffic on the basis that because the influx of illegal aliens into the country is so large that it serves a compelling government interest to be able to identify those individuals at a point before they get too far into the country. So there's a lot of detail regarding that case with regards to what the court ruled was specifically okay and what wasn't, but it involves a much larger analysis. The only type of federal law enforcement checkpoint that the U.S. Supreme Court has upheld was in U.S. versus Martinez-Fuerte. And the circumstances surrounding that case was based upon a permanent checkpoint installation. So it was well known by the local community. If local community members wanted to get around the checkpoint, they would know how to because it was well known, it was well marked, well advertised. So it was deemed all right to set up a permanent checkpoint installation within 100 miles of a border for the sole purpose of very brief stops to make queries with regards to immigration status. The court made it clear, though, that if the scope of that stop was to expand, absent any reasonable suspicion or probable cause, to include other things like the search for drugs or for other types of contraband, then that would most likely make that checkpoint unconstitutional. So we have a case where at the border, for instance, Customs and Border Protection personnel, which includes what used to be U.S. Customs and the United States Border Patrol, where if you're coming into the country or leaving the country, the courts have largely recognized a much greater degree of law enforcement powers to stop, search, and detain. But once you are removed from the border or its functional equivalent, the Supreme Court has indicated that either reasonable suspicion or probable cause is needed to initiate a stop unless you're at a permanent checkpoint installation, going back to Martinez-Fuerte, where they can make very brief stops for the sole purpose of making immigration queries. One of the quotes from that case was that, one of the fundamental protections of Fourth Amendment rights within a checkpoint stop is based upon limiting the scope of what that stop can actually do. And with Martinez-Fuerte specifically, they said this checkpoint is only lawful as long as it is contained to very brief stops and queries with regards to immigration status. But you look at how immigration checkpoints are conducted today, over 30 years later by the Border Patrol. Not only do they stop you to make brief immigration queries, but they have drug-sniffing dogs on scene. and they run these dogs around vehicles, absent any reason to believe that any particular vehicle is carrying illegal narcotics. Individuals are routinely detained for long periods of time, absent any reasonable suspicion, despite the fact that the Supreme Court said in Martinez-Fuerte that any further detention after the initial stop and questioning any further detention or search must be based upon either consent or probable cause. But yet, I have many experiences today, 30 years later, where I am stopped, I am detained for long periods of time by Border Patrol agents with drug-sniffing dogs on hand, with attempts to divert me to a secondary inspection absent any reasonable suspicion, probable cause, or consent, in an attempt to expand the scope of these checkpoints from just making immigration queries to all manner of general law enforcement concerns, such as illegal narcotics and other illegal contraband. So the Pandora's box was opened in 1976, and the abuses that are associated with these suspicionless checkpoints just continue to proliferate. And they're becoming a mainstay within modern-day society. I mean, there's not a major city across the country where you can't go where the police department in that city is not conducting some sort of checkpoint. You have immigration checkpoints. You have drug checkpoints, even though they're supposed to be illegal, that are being conducted in various places. You have safety seat checkpoints. You have seatbelt checkpoints. You have safety equipment checkpoints. You have documentation checkpoints. You name it, and law enforcement are just becoming more and more invasive into our everyday lives. And at some point, we have to say enough is enough. We have to draw a line. We have to bring accountability back to the way law enforcement is conducted in this country.